So welcome back to the virtual expert seminar on the protection of Sami traditional knowledge and intellectual property issues. We have been able to listen to very interesting interventions, and we hope that these can be used as foundation for the discussion. We have now a panel of some 10 people. Most of them have already had their presentation this morning, so we will have a brief introduction of the experts who are present at the moment. We will see who we have present here. I know that there might be some problems with the Jostein Sandvik to be participating here in the beginning, so I will give the floor to Rainer Oesch, who is an IP professor at the University of Helsinki. Are you there, Rainer, to give your introductory remarks?
Yes, I'm here.
Thank you.
Okay, it has been very interesting to hear all these discussions concerning protection of traditional knowledge, and it seems so that we should think this more widely and more liberally than we lawyers normally have been used to do it. And for example, Thomas Mattila mentioned this article, which is common in Nordic copyright, and all the Nordic copyright acts include this protection for classic works, which means that an authority can deny if somebody violates cultural interests concerning work which has been protected before, and this product has had an author or several authors. So maybe we should think about how to develop this article further, and maybe we should think about an addition of a specific provision on cultural heritage. And then we should rewrite the object for protection and define for this purpose the traditional knowledge more in detail, and also the right holders, which also can be a community in this context, and there has been very interesting points concerning who is authorized to give a permission or to give a statement on a certain matter or a product, for example. And then about the contents for protection in this respect, to my mind, it should not be a censorship. It could be a standard where you look at cultural values and not commercial values. And commercial values are more important in trademark law, and trademark does not protect cultural values, but they have trademark law has some aspects that, for example, international signs, international flags or national flags cannot be protected, and maybe there is also some place of rethinking about objects that cannot be protected in or as a trademark. But anyway, the role of Sami organizations, of course, would be important in the future concerning especially Sami cultural objects and values. And there was also interesting points concerning repatriation in one speech, so that I have found this day very very fruitful and very important and very nice to hear. So I have nothing to add at this point.
Thank you very much, Rainer. I like this positive atmosphere here, and I wish that we are now more focused on the opportunities that we have at hand and see how we could talk more about them and understand them in depth. So thank you for your words. I will now give the floor to Jostein Sandvik for his introductory words. Please, Jostein.
Thank you, Anna, and good afternoon from Oslo. Very sorry for the confusion about the address for the seminar, so I haven't heard anything before just now, a couple of minutes. I will address 3 items, and the first is awareness. Second, the concrete cases from Norway, and third, how we can continue work on building respect and recognition of Sami culture and the Norwegian proposal from 2006 in the IGC in Geneva. Last summer or spring 2019, there were many cases in the Norwegian media about the Sami sun symbol. I received a call from the Sami parliament to the meeting with the Norwegian industrial office. We very much welcomed that, and in August we traveled to Karasjok and had a meeting with the administration in the Sami parliament. We talked about, from the office's side, we talked about industrial property law, trademark law, and the rules relating to trademark law, and also the science law. There are 16,000 applications for trademarks in Norway every year, and around 1,000 designs applications. We also listened to presentations from the Sami Parliament administration and from Silje from the Sama Council. So we had a lot of interesting exchanges of opinions in that meeting. With regard to the case about the Sami sun symbol, we just referred to the procedures that we have and the ongoing case or the processing of those cases. We also mentioned the possibility of the meetings with the Sami Business Park, and mentioned that a colleague had participated there on earlier occasions, and we also planned for more meetings this year. Due to Corona, I understand that there have been no such meetings this year. I believe that Martin has already talked about the Sami sun symbol cases from our office, and but I'm happy to fill in something if that has not been already sufficiently covered today. But I'll just jump that and mention that we have had these cases in our office. My third item is how we can continue and work on building respect and recognition of Sami culture and traditional knowledge. And as you maybe have seen from my bio, I participated in the early meetings in the WIPO Committee on Genetic Resources, Traditional Knowledge and Folklore. And we had quite a strong Norwegian delegation at that time. And we put a lot of work into tackling issues that we found interesting. We had broad consultations also in Norway, and I must say that we sort of got good insights also from Ole Henrik Magga and other prominent persons from the Norwegian Sami community. So we felt quite into the issues, and that the things about building respect and recognition, we felt that were among the most important issues that we could contribute with. We had also experienced during the sessions that it was difficult to get any convergence of views. So in our opinion, we tried to put forward a proposal that could bridge those differences, and in that way we would like to build on existing ways and means to protect such things as traditional knowledge. And in our opinion, we came up with a proposal to build on the Paris Convention, Article 10 bis, and use that as a model for a new kind of protection. And we put forward the proposal to make a recommendation or any other international instrument in due time that could be adopted at the assemblies in WIPO, and in a document named WIPO/GRTKF/IC/9/12. We made this proposal, and it can be read in paragraph 38 in that document, and I can read it if it's not too burdensome to listen to. It says, recommendation regarding protection against misappropriation and unfair use of traditional knowledge. Paragraph 1. The members of the Paris Union for the Protection of Industrial Property and the World Intellectual Property Organization should assure nationals of member countries adequate and effective protection against misappropriation and unfair use of traditional knowledge. Paragraph 2. Any use of TK against honest practices in cultural, industrial, or commercial matters should be considered as actions in breach of paragraph 1. Paragraph 3. TK holders should in particular be provided with effective means to ensure that 1. The principle of prior informed consent applies to access to TK. 2. Benefits arising from certain uses of TK are fair and equitable shared. 3. All acts of such a nature as to create confusion by any means whatever with the origin of the TK are repressed. And 4. All acts of such nature that would be offensive for the holder of the TK are repressed. So I understand that it's burdensome to listen to such long text, but Anyway, this is an old proposal. Whether it still has merit, I don't know. It didn't get any support at the time in 2006. The document has a lot of words to it and can be read. I think we have put the finger on the shortcomings of the proposal, but also the possible good sides of such a proposal. I've raised 3 points: awareness, existing cases, concrete cases, and 3, the work on building respect and recognition. Whether from Norway regarding the Sami sun symbol can be sort of a positive signal that we have indeed achieved something during the years with regard to raising awareness. I hope that is the case, and I hope that we can continue to share awareness of both Sami culture and traditions, and also the intellectual property law system. I know that both aspects are extremely complicated, and I know that Norwegian businesses are not very good at using industrial property rights. I know this is much better in Sweden and Finland, but we are trying from our office to raise awareness with regard to industrial property rights. We are listening to Sami cultural expressions in the media, and there are so many talented authors and musicians and performers today that I'm personally confident that the Sami culture is vibrant and we learn a lot from it. So yes, I guess I will finish by that note. So thank you.
Thank you, Jostein. You raised really important points, awareness raising and kind of the momentum of having these cases in the media, because that really allows us to really engage also as experts in solving these issues, and also raising this old proposal from Norway, which really is comprehensive. So it could be also as a basis for future, and hope that we could have some comments from the experts also during the panel. So, but thank you very much. And then we go to the next speaker, Martin Fredrickson. You have the floor, and please share your views on the issues of today. Thank you.
Well, thank you for inviting me. I think it's been a super interesting day so far, and I'm really inspired by what I've heard until now. I just want to keep it short, but make 3 comments or observations, really. First of all, I warmly welcome a Nordic initiative for many reasons, because partly as has been touched upon earlier, international initiatives take time. There's sort of quite a lot. There's slow-moving processes in many ways, and also my impression when looking at many of the international initiatives is that they're also locked in the sections of the UN, in a sense that, for instance, when working with policies around the Convention of Biodiversity, Nagoya Protocol, it's hard to directly address questions of intellectual property rights, because that's WIPO and UNESCO, and culture is UNESCO. So you have those fragmentations in international law that I don't think you have as much in the Nordic, on the Nordic level. And it's also, I think it's also fitting that the Nordic Council takes this initiative now, because if I'm not mistaken, I think the Nordic copyright laws of 1960 and 61 were the first coordinated initiative at a Nordic legislations after the passing of the Nordic Council, or formation of the Nordic Council in 1952. So it's kind of fitting to use that, to build that on a Nordic platform. So I think more can be done on the Nordic platform. And I also see that in how people discuss today, that there is a belief in you that you can actually use the law in ways that you quite often don't see. Quite often you feel that the law is already locked, it can't be changed. So I feel a sense of a visionary sense here, which leads me to the second question, second observation, and that is a recommendation, or maybe hope, that we can look more to see what we can do with the concept of moral rights. Now, copyright is traditionally, Scandinavian continental copyright has traditionally been divided into economic rights and moral rights, where economic rights regulate, well, it is what it sounds like. It regulates the right to sort of sell and exchange your work. It regulates the right to collect the revenues from it. While moral rights, on the other hand, refer to the rights to be acknowledged as an author, but also the right to be respected as an author. So it connects to the rights of the integrity of the work, the integrity of the artwork, and the integrity of authorship. And I think moral rights in that sense maybe better reflects many of the problems we're talking about if we're talking about protection of traditional knowledge or traditional cultural expressions. And I think one of the reasons that it's been hard for the international discourses around intellectual property rights to deal with traditional knowledge is because they have been focused quite a lot on economic rights. And that's because economic rights is a strong tradition in Anglo-American copyright law. And I think here Scandinavian law or Scandinavian legal thinking can have something to contribute, because we have a long tradition of moral rights. We have used quite a lot of moral rights. And I think we can sort of help also at an international level to expand the thinking about moral rights and how we can use moral rights in protecting traditional knowledge. Now, the example of the protection of classics, which has been mentioned, is one example of that. That is a more, in a sense, you could say it's slightly odd version of moral rights in the Scandinavian copyright laws, or Nordic copyright laws. I've also been toying with that idea in the past, so I'm really glad to hear that this idea is picking up of using the protection of classics in this way. When I first started thinking about it, I saw it as almost a provocation in a sense, and I didn't think that it would ever actually be possible to use it in that way. I tried the idea at a conference with lawyers in Amsterdam, and they objected that the European Court would in the end not accept that, because they would see it as a violation of the European Convention of Human Rights, the free speech provision in that. On the other hand, at the moment, we see the protection of classics actually being tested in Sweden, in a Swedish case. So I think that could also sort of give some perspectives in the future on how we could use the protection of classics. So I think it's a good idea to keep the eyes on the protection of classics specifically, and more look at moral rights generally. And the third point I want to make, is that I think it is very important for lawyers and people working with intellectual property rights to learn from other modes of regulation, to learn from for instance, so-called customary laws. Because as we see, there are many ways of regulating the circulation of and uses of knowledge and cultural expressions. And I think there's much to be benefited. Intellectual property rights have much to benefit from learning from customary ways of doing that, for instance, in relation to music, in relation to York. Not only because intellectual property rights have to adapt to those expressions, or have to be better at accommodating those expressions or protecting those expressions, but also because intellectual property rights have to, especially copyright, have to be better at, have to adapt to a wider range of different kinds of expressions. I mean, we see that discussion in relation to digital cultures, in relation to circulation and collective creativity online and so forth. And in some cases, I think the challenges confronting copyright in relation to new media can be actually quite similar to the challenges confronting it in relation to traditional knowledge. And I think by looking at customary ways of regulating the circulation of traditional knowledge, traditional cultural expressions, intellectual property rights and copyright might in the end actually be better adapted at regulating a wider range of cultural expressions of all kinds. So that's sort of just my few quick reflections on the discussion of today. And I'm, as I said, I'm really glad to be here. I'm really enthusiastic about what I'm hearing. I'm looking forward to how this is going to progress as well.
Thank you very much, Martin. I think you raised really important points: legislative cooperation, moral rights, and the protection of classics. Which it's interesting to hear that it's actually being tested because there are so few cases, so it's very difficult to know how that would work. But I think in this positive way, we could try on the Nordic level, see how that could work in principle, at least to make a study or something like that, and to as a next steps and somehow like map, as you say, the existing systems, and because they could be adapted. I think also we could think of IP as in a holistic manner, which we haven't done, and maybe it could evolve. But this needs discussion. Now I would like to give the floor to Petra Magga, who representative of the Sámi Duodji Foundation in Finland. It's really important to hear her views and concrete views about the new Sámi Duodji trademark solution. So please, Petra, you have the floor. We will come back to Petra as soon as possible. We can, meanwhile, if Tuomas Mattila is there, maybe your reflections at this stage, or any other speaker in the panel who would like to comment, Silja Zombie, for example, on these issues. There is a hand raised by Rainer Oesch. So please, Rainer, you have the floor.
Yes, thank you very much. One idea would be to create a voluntary register concerning products or traditional knowledge, and I have not followed so in detail the international discussion, but we have this kind of registration system of well-known marks, which is not legally binding, but it gives you an expression and a presumption that this mark is well known. And also, if you would or could create within patent administration such a register, would be one idea, but I don't know whether this has been object for discussions in the international fora or not. Maybe somebody could comment on that.
Thank you very much, Rainer. Yes, that's one point. I will hold, or maybe, yes, Jostein, if you really briefly can answer that question of Rainer's, and then we will give the floor to Petra, okay?
Okay, I can be extremely brief with regard to well-known marks in the register. The issue there, as we see it from our perspective, is that the well-known mark protection is extremely flexible, and a mark can be well-known at one point and then have a broad protection, and then the next decade or in the next year even, the mark loses this protection and the register is not anymore up to date. And such, at least from the trademark perspective, that is extremely important. And the well-known trademark protection comes from the need to avoid free riding and these issues. So I'm not sure, I haven't contemplated how this would be with TK and TCs, but I guess there are other concerns on having such rights on the register. So that is very brief from my side.
Thank you very much, Jostein. Well, it's something that to consider. I think there's just one in the list of issues that could be looked at. So please now I would like to present Petra Magga. You have the floor, Petra.
Sámi Duodji-servi tahanle Duodji-servi ja mulla on täällä otne outtasteemme tämän Sámi Duodji-servi. Sámi Duodji-servis. Tällä juoka tämän nehtä saattaa potke. No koihtohke. Just tälle Sámi Duodji-servi tsekke juoi tuha hohtsuoli tsetsoloi vihta anaris, jos muistellaan tämän Suomen Sámi Duodji-servi historia anehadjat. Just tälle, kun Sámi servus alkii lihkadit, alkii huomasi tai aihtakit, mahlet pohtime ja alkii huomasi tämän ahte muu, mikä kalkkasemme nanne edjamme halap muka. Tässä servillä aina tuojariservi mi kähtsää perrai, tämän tuoji mi kähtsäällä vaikui tuojari pyrkäjubmai, outtita puhtan tuoji uahpama ja suotsala arpe virolas Sámi tuoji. Ja tällä Sámi tuoji servillä parakan ouhtas riihkäräjirasta ja aalohlle parakan, mutta tällä entä liiko hastalusahle lassanan ja nämä lassitaan Sámi tuoji säilyhemmes ja hälttäsемmes. Duodjihan siis tuolla hirpma hollu. Alku saapmelasella tahkan tuudjon kielai kuin puhtai hatnotinkkai piktasi tjynjai reakai ja niin ainouttas kuului. Tuudjomi ja tuodjailla chatnon nuu ollu saamme kielä, märkkäsuumi, terminologia, tiihto noropmai. Arpevirolas tietui ja taittuit. Tuudjan alkaa tien raajes, kun aunasteemme alkaa. Ta hiilehtussetan tuoji he karvis tuodji, mutta ta alkaa jo miha outal tan luontu ja maanu juovumis. Luontu kalka lähtihtoläjäi karvis tan tuodjomi. Tuodjon kulla hui chauka Sámi jahkodahki ja tas Sámi jahkodaht tahteko juohkaa tuojara parkkui tihtoaikkite. Maittai, jos me juurtilihtaan meidän ällimaa ja tämän ällin vuoki, tähän kuullaan hui chauka tämän luontuaihtsami, mutta maittai meidän arpevirolas eläusaite. Ja tälle, kun juoka tuodji tuudjojuvo, tahi tuudjojuvo päivis, i kuofti päivis, i vahkus, mutta tah tuudjojuvo tihto ja chat tuntui teinalaakin ahteta materiaala läht oadjumis, taht parkovuoki läht chadahemmes ja ahtetan tuoji säilyhämme ektui maissahtaa vähän smiehtaht mun parkkan säilyhän taje koihkalantan tuoji. Teuske arpevirolas Sámi Duodji i läht nakodan just taihaikki kilivali nu puurestain na fabriikka ma tinkkaikuin. Mieh kohta tai tuujin vaihkota sulastahte min tuoji. Teuske kola takar nukohtsuun outomerkati turista. Olmoski haalida oasti vaikka kuussi. Se on sahtaa väljehtan halppes kuussi, millä rahkaduvan fabrikas kosnu eräsaisko saamis. Misllä huijallu hastalu sahti uske? Mi haalidi säiluitan iätsämme kuuttasarvuu. Tähän lää tiihtelas. Tähän lää paaristeko äänätä Duodji. Tählää okta tehalas min kuuttasarvuin. Täh juokalahkai maittai nanosmahtaa sääpmeladja. Ääräarvulle kiellä sohka, luontu ättejupmi luohti, Sámi Elähusa ja ollista hellin vuohki chatnaa tai tokti. Ja puhtahla kävikäjulkkiht, mai pokte millä hain kaudnomistan maailmis. Puhla tällä takkaras ashit, mai kalkkasi outtidit ja mai kalkkasi sutjat. Muhtu niitä Duodji lää valto Elähus. Elähus maskalaka tiineht oadjo tänä laippipöyttäjällä. Muhtu niitä tällä siito Elähus arpevirollas Elähusa palttas. Nuko saamme kielahke lää aihtojuvon kiela nuulää Duodji maittai. Ja äärenomaas aihtojuvon suomaskoih lähtää nuorahtalas ja anara Sámi Duodji arpevierut. Mas muistella tiehkeähti tämän jouhkuin ei lähkö Suomessa tuojarahkea halttasi Duodji ollislatjat. Saattaa nähdä lohkat tai hastalusai mahläht otna päivä. Nuko otneke tällä kullon tai saahkavuoruin tai koskaan teuskemiin tällä plagieren tällä halppeskopia. Tällä tahkaa hastalusa tuojari muun pirkentän markkanastimis, kun mun parkkaan kielai kuin tämän arpevirolastuoji. Stereotypia piepman sosiaala medias ja puastu informationa juohkin tämän pokte lä okta hastalus tuoji ektui. Turismas käyvähuvon kauhtit ja kauhti sulastahti piktasaht malla jo taipman suomas olle kuhkaa. Tahla maittai okta stuora ashi masa ehtalas nolkkausa kalkkasekke pasti huijodanit vaikuhit. Maittai kauhti tai tuoji oosi luikkahallan. Ona outa märkätitte kauhtista ja mäyreskaarin vuonjalla symbolain. Tahla mai okta takkar mi tahkaa vattisin chilikehtan oloko maailmai mi makkar konteksti tah riftimöltä kullaa. Lääkoti lohpi auhkastallat, lääkoti lohpi suoladit. Suolaneemes sahtaa hupma maittai dan ahte, vaikka ole saahka konkreetta kulttuura iesvuota pirra nuko Duodjis ja tuoj. Oktamin tehalas oessi tahe Duodji lä kakti. Kakti lä suoladuvon tinka. Talko säpmelas merostallan, sämetikkilaaga odasmahtimaa pisaneepmi, lä tahpahuvan olles aike, miehllä päässän tihtolajetitte mihtomeeritte kosamille haalien politiikkalajat. Tällä vaihkuhan noloka maittai takkar konkreetta immateriaala kulttuurarabai. Tällä vaihkuhan tiesä ahte lääsattan teko kilvu viehkan identiteettä ohtsamis ja tälle sattaa tuohtan taht ahte alkualapmokiitta kuulevas tjeleka toutomerkka lähtö huikeasuhetjit ääräite ja pohti saamiservosa olkkopelte muhtoke haalidi joksahtan semma otsolohkat identiteettä kom misleä. Tauru arte ahtetaan sahtaa täyti takkar konkreetta tinkkai kuin nuko vaikko kakti. Mulleken pithän tohko takkar symbolai tohko tiitte diaitte. Ja munin ieslähtääl manimusaikki parakan aktiivalatjahtan Sámi Duodji service, mutta lään tjuuvon tan määrä ahte tah määrähkä paraku lää vuolakan johtui hui aktiivalatjah ja puures ja ootjo lohka taverihkalas parakun. Ja tää lähtäkkär symbolat, mas lähteko taht Sámi Duodji määrähkä, kalvomäärähkä, millä jo vuoruutuvan outal. Ja telivtsi tan palti pohtimme määrähkä, millä ta palttas. Miteko muistella tan ahte tah määrähkä karanteere tan ahte tan tinkka lä tahkan saapmelas, mutta tah ilät ärpevirolas Sámi. Nuukotan kuruhpelte symbola fas tahe märkä, kalvomärkä outtiita. Ja lähui tehalas ahte mi nakoodi haitnihtan, ahte mi tarpas pessu taas ahte puhkalla ärpevirolas tuojarat. Muhto mi sahti maittai atti veolas vuodai tiitte Sámiitte kehäälidit hutkaht ärpevirolas tuojii vuodul odda tuujit tähän piktasit tai tjynjait ja sislää maittai teko sertifikaahtan taht määrähkä. Tai määrähkä i mun mielas mun tiedon mieltä lähvel nannejuvon. Määrähkäihan oamasta Sámi räädi ja taht Sámi Duodji säärävit odjo lisenssaitoitte määrähkäi. Tieppe loahpasle takkar Suoma Sámi Duodji säärävi odda logo, millä fas Sámi Duodji säärävi vuollin toipma takkar Duodji shop ja tahtsaajaha tan Duodji shop takkar kauppe märkä symbolla. No, tämän päivis lään nuuko Sámi Duodji servi outtastetjin odjon huimielakittevas touttuit ja juurtakit. Haalitan kal ain nuuko outtitihtan taverihkalas outasparkku. Nuuko millä manki smiehtan peytti pirra, ahte maihmii sahta tatjat ja man karrasi mii sahti pitjahtan suoji. Lääko mis rekti jälki juovieru Duodji ärpeviru pirra. Naa Suoma saapmelatjan. Ko saapmelatjahan läht maittai Suomas ruohas norkkas ja ruossas. Ja olles ärpevieru ja ärpetiehtu lä oktasas. Ja talleta kaipida tan, ahte mislä oktasas linjen man mii juovut. Olles aikki tahpahuvata sisäpahken Sámi kulttuuri ja tahlä maittai tuohta konkreetta oositte, iitusse etnamitta ja tsaasitte, mutta maittai tuoji ektui ja elähusa hektui. Tietuskemi haalidivtsimme ahte märhkat sahtosekke pohti häikke mauhtiidahtit, maittai tuojarit, empotoi märhkai kevähäpmai. Ja vaikka globaala trendat, nuuko odjolohka piuhtashäpmen fashion ja takkarke negatiivilla trenda, mi kokcha olles äänanspaappa lää talahkata reutan. Vaikka tästä tiurei maailmi, luahpas alako alapmuki kaskas, ärpevieruht ja ärpetiedut ja ärpevirulas Duodji äämihektui lää tahmi kuottaatan kulttuura outskuului. Talleko juoka lää i mananu puures Sámi kulttuura oosiin, vaikka politiikkalas joksamis, politiikkalas Sámi politiikkas ja tan teko outtiteemes. Sahtan karanteere ja lohkahahte Duodji ja takkar voingalas päälli, teko voinga Duodji taitta ja filmah lähtaht ma empolehtalle areenas. Ja Tasa lohpi sahtaan lohka maittaitan ahte. Tietuske millä hui ollu haalitan ahteta alapma tiehtuu. Tah joksaa olomuit. Ja ahte suoma vuotos kuulas sahtasi jo alekihtaht alapma tietujuhkin. Tämän sahtasi chatnahnuuko ahpahuus ja kulttuuriministeriöllä jo outalta saa chujuhannu Sámi alapmapäivä kueski toimain vuotoskuulas. Mutta maittai ahpamateriaala kalkkasi päivität. Sihke attit puohraje alapma tietui millä Sámi Duodji. Sámi Duodji chuovula hui ollutan Tuomas Mattila chilikehusa. Toppelata tahki poika huolta lahka ja klassikko suetsi. Mi lähteko takkar man sahtaa just tal heivehit. Tuotsai ja kaktai. Kiitos.
Thank you, Petra, for this presentation, and just wanted to say there is a broader presentation of Petra available in the portal. But it was actually just looking at these embroideries in the dresses. They seem like a story, a book. So basically, a living person wearing the Sami dress is a living book, and we could think about it in that way as well if we want to. So now I would thank Petra and then go back to the panelists all together. I wanted to ask if any of you have some particular points that you want to make. I think Petra mentioned an important point that we need to have more awareness raising for children and new generations into what is Sami Duodji, what is the meaning of Gakti and the Sami culture, because we are all much too ignorant as to the deeper meanings of these cultural expressions. I wanted to, before we go into that discussion, to raise this slide here that you can see. This is the guidelines that were mentioned in the presentation by our Director General, the ethical guidelines for the Sami tourism or Sami culture in the tourism of Finnish Lapland, which has been the foundation or the first kind of place where traditional cultural expressions of the Sami have been used, misappropriated in the tourism industry, and that these guidelines have been published in 2018 and accepted by the Sami Parliament and funded by the ministry. And I thought that we could have comments based on the questions on the slide. Sorry for the questions being in Swedish, but I can repeat them. Question A, what would be the next step in the Nordic context with regard to traditional knowledge and IP? And the second question would be how traditional knowledge could be taken into consideration better in decision making. And in under B, I think we can also discuss the defensive protection of TK in for example, patents or trademarks and designs that are being sought by third parties, including something relating to Sami culture. So these are two questions that I would like to have some replies to. I also would like you to urge to look at this picture, because this is a very interesting, a good picture drawn on commission by Sunna Kitti, an artist, a Sami artist, who in this picture tries to present the positive kind of the way that Sami culture and Sami people would like to see their culture being treated. And I think here you can see many types of freedoms, and most of them are that there is cultural freedom, singing, dancing. There are freedom of providing products under the traditional livelihoods of the Sami people, and with regard to the dresses, that they are free of using their own flexible way in their own culturally sensitive, their own context, and not being duplicated, like Petra was mentioned, by Chinese copies or something like that. Okay, I see some comments. Can I have some hands raised? Anyone who wants to comment, first of all, in the panel, members of the panel, please.
Well, Thomas Aslak could have the floor.
Okay. Yes, Thomas Aslak, you have the floor.
Thank you, and thank you again for everybody that have contributed to today. From my opening statement, I think that we have been really much contributing and adding different levels to that statement, and also as we clearly stated with Aili and Per-Olav, the presidents of the Sami Parliament in Norway, Sweden and Finland, that the Sami parliamentarian cooperation is putting focus now on the traditional knowledge and cultural heritage, on finding common ground in the Nordic context, and the discussions and representations have been really much adding depth to that. So I really much appreciate that. Your questions on how to move forward and how to move forward on a Nordic context as this panel topic has been presented. It's a good question. I think that what is really crucial to remember is that this is a right for the indigenous peoples. So this has to be led and solutions coming from the Sami community themselves. As we were in the morning stating, the work has been starting now, and I think the Sami cooperation has to identify how and whether which model could be used in our edition. I'm enough thinking of using the Nordic cooperation in a positive way. I think that if there are commitments from the state side to support this work, there are opportunities to get results. We often restrict ourselves on the existing mechanisms what we have, but I would hope that we would also consider opportunities to build something new. For example, if there is a will and if there is a way, there's nothing preventing us on building a legislation that would, in a Nordic context, to secure the Sami traditional knowledge, that the usage, the misusage, and so on. The discussion now on the expert sides, on the legislative side, has been maybe only solely focusing on the basis of using existing models, and whether the Sami collaborations found that as a good tool or additional tool. I think that is, of course, something that we can try to use and see whether how it fits. But I would not exclude the possibility to have a Nordic legislation on this matter that would be specifically made for the needs and interests of the Sami. As in my opening statement, I was saying one of the examples, Joik, is a good example on how it is difficult to try to use the Western or the current legislative normatives. Although I do agree with my friend Thomas, and that they are, and the classic model can be thought to be used in a more better and sufficient way. But of course there are let's say walls or restrictions how much you can get help for the legislation, and therefore the trademark aspect is of course important to be also developed and further used We are not alone in this world, and I think that is one of the challenges in WIPO and the ICG also, that after 20 years, states haven't been founding resolution or results there. So that indicates that this is not that easy. I do agree, though, that I think it was Fredrickson that was saying that in Nordics there are a certain level of moral responsibility on trying to take care of issues in a well-mannered way. I think there are, of course, those companies in the private sector that are doing issues wrongly, that don't care and might not even know about issues. But there are also those that are trying to do it good, and also in the, let's say, nation building or society building in the Nordics, the moral aspect has been strong in the 19th centuries. But I do have to, though, remind that today the morality is something might not be showing for the Samis, especially from the state sides. Even though the private sector works with the different rules, with so many ways, and there are bad and good examples, there are also the morality aspects from the state side and how states are showing those. I would have to say that I am a bit concerned what's happening. If we, for example, look what is happening with the sacred sites in Norway, we have this big wind industry trying to come to for example, Tavvi project that is coming to sacred areas of Samis, and that is exactly what we are talking about here, trying to secure the traditional knowledge in actual usage and sacred sites and so forth. But the governments are not building those protections strongly in practice now. It might have been the case in the 90s, 80s, and where the human rights approach and the nation building spirit in the Scandinavian countries was more human rights approach based. But nowadays, I have to say that I am concerned. So therefore, there is no time to waste how we can work towards together. Whether there is a commitment from the Nordic state sides on trying to find solutions, I think that the Samis will be finding solutions. How do we see our aspirations to be fulfilled in this field, and hopefully we can have a dialogue with the state sides on trying to find concrete steps how we can work together. The Nordic Ministerial Council is an interesting opportunity, but I although have to also remind as a leader of the Sami Parliamentary Council that the Sami Parliamentary Council has been trying to be a member, trying to be knocking and asking the allowance to be in the room for a long time, but still our membership hasn't been taken in as a valid ground. So there are, when talking about the moralities, respectfulness, there are still those steps in place where we are not treated equally. Whether the majority societies understand that or not, it might be one challenge or problem that we have to resolve in order to be in a place where we can openly find solutions and make it better. But the big priority, as you have hopefully understand from today's morning, from the Sami Parliamentary Council and the Sami Parliaments, and we will be trying to find common solutions and common normatives from the beginning. Thank you.
Thank you very much, Tuomas Aslak. This was very, let's say, good summary of the kind of feelings of today. And I think what you raised about the support from the states, I think this is what we are trying to achieve by collecting all the experts in these different areas that touch upon TK protection together. We would then much better be able to support the Sami, while the Sami are then also developing the way that they are dealing with the common TK management issues. Also, of course, the idea of looking at the current system does not exclude any new solutions that would be needed in order to make the protection whole and fully encompass the needs of the Sami people. But I think here we still need the step-by-step approach in order to understand that when legislation is then being developed, that it's compatible with the existing system as well. That's a very practical thing in order for the final system to work properly, that we don't have legislative uncertainty there. So, and also finally, with regard to the representation of the Sami in different contexts, I think it's an important point that you raised, that the Sami need to also be represented in these negotiations, and we will try to influence that also with regard to the presidency of the Council of Ministers next year. All right. Thank you. And now I would like to ask for further comments. Tuomas.
Yes. Hello.
Okay,
hello,
great.
Anna,
Tuomas,
and
you have the
everybody.
floor.
If I may. Thank you. Yes, thank you everybody from my part also for these extremely interesting presentations. It's been real delight to listen this, and I think I will just recapitulate some of my thoughts, some miscellaneous.
If it works.
Sorry.
Camera, please, Tuomas, if it works.
Just a moment. Okay, do you see me?
Yes.
Okay,
Good.
let's hope we have a connection working. But yes, all these presentations and speeches, I think they illustrate very well that how broad and multidimensional theme we are talking about when we talk about traditional culture and culture as such, and it's just like we see that there's tangible, there's intangible assets. They are intertwined in many senses, and like coming into this discussion as an intellectual property lawyer and looking from very specific viewpoint of law, I see that this theme is much broader and larger. And I would say that already for a legal professional, it is challenging. And I can just assume or imagine that somebody without legal expertise, all the talk about trademarks, copyrights, and this broad, it might be a bit confusing and difficult to grasp. And so once I thought also that we can also think from the goal point of view, that if we think that the common object, the desired state of affairs is that the continuation and maintenance of traditional culture, I mean traditionality of culture, those elements, aspects that make culture traditional, that they may remain and stay vivid and continue in their own organic terms. We can also think that, and it doesn't mean that the traditional culture is static or doesn't change. Yes, it changes, but it's not like forced outside to change, but it's more like inherently changing in social transactions within the communities. But so what are the threats and risks and challenges that are facing, that the traditional culture is facing, and how these threats and risks can be answered or repelled? And from intellectual property point of view, it's obvious that there are very certain issues that can be quite well counteracted by IP tools. Let's say unjustified commercial exploitation of certain symbols or signs or such. Then there are other issues like we heard, reindeer husbandry, fishing rights, sacred places, the over visiting of sacred places, which might be very difficult to grasp from IP laws. Then there are other laws, of course, that might come into the picture. We see that it is very like only from the legal point of view. Already we are talking about quite extensive phenomena. So it might be difficult to just to grasp the starting point. But so from this line of thinking, maybe we can approach that to these basic questions: what current intellectual property tools can do, what can be achieved by using the IP tools that we have now, and as a next step, I think it's always important to continue this kind of dialogue, which involves legal consultation, that the Sami decision makers have good, and I don't know that they have already, but always to have like strong foundation, legal knowledge, that what is kind of like what kind of tools there are right now. And as I pointed out in my presentation, that it's not only legal analysis in this sense, but it must be also like, let's say, usability analysis. How applicable are they, accessible, efficient, usable for Sami people and communities, these intellectual property remedies. So from this kind of like a dialogue, consultation, knowledge process, I think some kind of like recommendation can be reached, which also in a way might answer to the question that like Tuomas Aslak pointed out, that it might very well be that some kind of wholly new legislative element would be needed. But I think it would be important also that to that route, we could provide an argument, a profound argument, that the current IP tools or other legal tools are not sufficient. So I just mean that still like dwelling down into this, what we have, options that we have now, might also this discussion might provide beneficial for argument that new legislative tool is needed. Well, I just say finally one last thing, that and all that we have to keep in mind, that also these intellectual property tools we're talking about, still we could say like hard measures. IP tools or IP rights are always like exclusive rights to prevent others from doing something. So it's quite hard measure. We've heard good examples, and there exist soft measures, guidelines, ethical guidelines. For example, the guidelines of use of Sami dress, the guidelines, the photographic guidelines, because there's always like, for some part of the actors, there is goodwill and the consumers' goodwill to operate in ethical terms. So I think that these both elements are inevitable and necessary, and so not to forget that. Maybe I leave it here so I don't take all the panel time, and thank you.
Thank you very much, Tuomas. I think those were really good points. I really would like to see a tradition of culture changing than just a tradition of culture being stuck. And I'm talking about how the IP system is thought of working and what it can encompass, and also bringing up the soft measures on top. We have the next speakers. We have Matilda Månsson, and then we have Martin Berger. And please, you have the floor now. Matilda.
Thank you. Yes, I wanted to follow up on two things that I feel have been general red line, if you want to call it that, during these discussion, that there will also be my takeaways, and also something that I think will be main issues to think about when continuing these discussions. And one is around knowledge that both now Tuomas and Tuomas have highlighted, that we are here in a group of people who are have knowledge about these issues, and we need to remember, and that is, I think, what we see a lot in our work, in discussions with government agencies or in discussions with the government ministries, that the general knowledge about Sami rights, about livelihoods and culture is very low. And of course, then that sets the starting point of discussion also at a very low level, which means you always need the time to first create the context, and then you can get into the discussion of what are the needs, what are the ambitions, and so on. So I think this initiative is from that perspective very, very important to make sure that we all start the discussion with a shared understanding of what is the problem and what needs to. I think that is Tuomas was very clear in highlighting that is a work that the Sami parliaments have been conducting together to meet and to identify what is the work that we see needs to be done and how can we do this. And I think that brings us to the other aspect that we could call maybe, I don't know, governing structures or so. So we see that within the parliament, we are covering these issues in the main different fields. And I can also add here, when we talk about the global context, we have also the discussions around traditional knowledge in the Climate Convention and under the newly established platform on indigenous knowledge as well, where there have been discussions about database for traditional knowledge, which is not at all what the purpose is here. It's about what Tuomas Aslak was saying, that it's about ensuring the participation, ensuring that the indigenous voices are being heard. It's not about creating a platform where traditional knowledge is collected, because the traditional knowledge is something that is applied, and that is what's happening in the decision making, but it can also only be applied if you have the consent of the knowledge holders. So that is always to, okay, if in the international context we see then that if there lack of knowledge on how to talk about these issues, then you arrive at the wrong conclusions and not addressing needs of indigenous peoples. And we also have this discussion within the FAO in the UN as well, where we talk about food sovereignty. So these issues are existing in many different fields, and I think that is something that one needs to be wary of. That from the Sami parliaments we have this knowledge gathered in one place, but whether as government level you have a ministry for environment, you have a ministry for enterprise, or their ministry for justice, and to have these different parts of the government to talk to each other and then to align to make sure that what is happening at the government level is actually anchored in the needs and the rights and the ambitions of the Sami. So I think that is where this alignment needs to happen, which might be a challenge. And I think this is really why this webinar is important, to try to maybe fill those gaps and to avoid us from talking in silos, and to understand that both in a global and in a national context, discussing traditional knowledge and traditional cultural expressions really means a holistic approach and a rights-based approach. Thank you.
Thank you, Matilda. Those were really good points, and really shows that, you know, there might not be any fora, actually any international fora, where indigenous issues would not come up in principle, because they are part of every section of life, as they are, as there are issues, specific points of views that need to be taken care of, and the only way to take into consideration these issues, if I understand you correctly, is to have engagement with the Sami themselves. That's the only way. So not trying to make solutions from this sort of government side without having the consultation with the Sami and with the Sami representatives. So I think that's something that we are hoping to establish. And also we have this one example of the traditional knowledge network, which we also have from 2012, and it really has 45 members from different parts of the ministries, but also from the Sami parliament, and also the universities and so forth. So we are trying to encompass that. Do you think that would be one of those possibilities, like next steps, to establish this sort of a network as a first step, and then to help find the correct people? I'm asking Matilda if you can react to this idea.
Yes, there's always something you need to mute and unmute before you start speaking. Yeah, I think that is one of the key things to identify who are the key players, or who are to identify who can be involved in this kind of work. And then, of course, from the Sami parliaments, but there's also Sami civil society and these organizations that have been represented also here today, and also then experts from government agencies and also from the government. So there's definitely a process in itself to identify who are the key representatives to take this work further, and also, of course, to respect the internal processes of how to anchor this within the Sami society.
Okay, that's good to hear. Also, now I think I have a list of speakers. I put them in the chat. So I think the next one was Martin Berger. You have the floor. After that is Silja Zombie, and then Johan Axham. So Martin Berger, you have the floor.
Well, thank you. Since I am in the panel, I feel I have to say something. Although it's hard to sum up a day like this with all this knowledge that you have from, and that I have received today from all the participants. My take on these issues is that I come from the legal intellectual property perspective, and when I now am engaged in this forum, my thoughts go to how can we make traditional knowledge and cultural expressions to fit in the current IP system, and how should we come forward? Because my concern is that the legislator is not so keen on changing the actual laws, the legislation, and it's also a problem, I think, that, for example, the copyright law is not created to protect traditional cultural expressions and traditional knowledge. But maybe by case law, as we have seen with the Sun case in Norway, we could, that could be a way forward. We can kind of force it or make the legislator to think differently by taking these cases to the court, actually, and put these important questions on the agenda. From our office perspective, the Swedish Intellectual Property Office, we have an assignment from the government to raise awareness in IP, and currently we have a focus on SMEs, and of course Sami entrepreneurs are also small and middle-sized enterprises, and we have now taken measures and initiated cooperation with the Sami Parliament, Susanne Idwoma and Ingela Nilsson, for example. We have had some meetings, and we will continue our cooperation, and that is something that the Swedish Intellectual Property Office would like to go deeper in, and we hope that this also could be beneficial for Sami entrepreneurs to actually use the current system with trademarks, registrations, with design registration, and then so they can and benefit more from the current system actually in their enterprises. Yeah, I think that's all.
Yeah, thank you, Martin. I think you're raising good points as well. Normally the legislator, whoever it is, of course we have the national parliament who will make the changes that are proposed, normally never willing to change. So I think what we need is what you mentioned is case law. We need to get the awareness in the society that the current system is working or is not working, where are the problems, and then from that, move forward. We get the cases, we get the evidence about what is actually the change that we need in the law. And what you mentioned about SMEs and the focus that the IPR strategy in the EU is now on SMEs. It's completely okay for them to encompass the SMEs of the indigenous peoples as well, because of course the protection per se of TK and TC is one thing, but there is aspects that can be protected anyway or by the pure IP systems themselves, and it could be useful to have this sort of understanding that the IP system is there for the individuals and for the types of expressions and products that are not entirely the TK, but are something in between, like the Sami Duodji marks, for example, were showing that these are Sami made, but they are not following the exact Sami tradition. So these are not excluding each other, the systems, they are complementing each other. All right, next speaker is Silja Zombie. You have the floor.
Thank you. So many interesting discussions here. I hardly know where to start, which one to comment the first. But I wanted to go back maybe to the initial questions you were asking, for instance, decision. How do you reach to a decision? And in order to achieve a good decision, you have to have the understanding and you have to have the knowledge in order to get that decision, a good decision-making process. So then you have like the traditional Sami traditional knowledge system, which is such a huge field. It's like we've been discussing all kinds of levels today. It's been Duodji, it's been Luohti, it's been land rights, and it's also about water use, education, customary law, you name it. It's everything. And also the language within is that what is traditional knowledge? Somebody is saying it's science, and others are saying that it's culture, so there are so many parts of it. So it's very important that we maybe think about it from a Sami perspective, that we have to go into this and focus as this also as an internal process. That we also get to do this internally. And one principle that we have is nothing about us without us. And that is a very important principle that I think many have raised up here in various forms. And there are 3 levels also in this. You have like non-offensive use, traditional knowledge and TCE, and it should be in a Sami control, and it should also benefit us. So this is maybe what also like Matilda was talking about. It's a holistic approach or a rights-based approach to this kind of questions. And I also wanted to comment on this Davi project, Sacred Site project, because when I was looking at that Davi site project, which is a huge project in the northern Sami areas, where they're planning this huge wind industry area in the middle of a sacred area. And when you look at from an ICH convention, it's like the talk is about safeguarding. But can you safeguard something that should be protected? And so it's like we're saying that there's a lack. How can you get the current system to benefit the needs that are there, and when the traditional field is also so huge, and you should have that the current decision-making system should fit into this, or the Sami traditional system should fit into the current decision-making framework. I'll stop there for now.
Thank you very much, Silja. Pertinent points as well. Now I give the floor to Martin Fredriksson. And yes, Martin, you have the floor.
Just a quick reflection. First of all, on the topic of new legislation, I mean, that's, as mentioned, is something that WIPO has been discussing for a long time, but never really get around to it. So it could be worth at least raising the question whether it's the Scandinavian countries should take a lead on that, because maybe Scandinavia is, or the Nordic countries are, it's a good size in a sense. It's a platform where that maybe that could be done. But what I was mostly thinking about is the question of doing what we can with the system. One thing to consider there could also be licenses, Creative Commons licenses, traditional knowledge licenses, in a way to sort of build the system within the system, and adapt the uses and circulation of traditional knowledge to the actual knowledge and the needs of the knowledge and the needs of the community. Like, I know there is an initiative called Traditional Local Context. I don't know if you know about it. I don't know much about it myself, but who are working with traditional knowledge license. I'll post a link. Post a link in the chat. That's pretty much it. Thank you.
Thank you very much. I will ask now if anyone else in the panel would like to lower hand. Like to comment at this stage, or should we go to the rest of the speakers? There is the next slide where we have the possibility for the discussion from the audience. Because Jukka Liedes will of course have his closing remarks, and he will then touch upon all of these issues that have been discussed today. So I think he has agreed to that. And the next speaker I have from the audience is Johan Axham. After that, I believe it's Jukka-Pekka Timonen from Kopiosta. But Johan, you have the floor.
Thank you very much. I hear me. Please indicate otherwise. Thank you very much for arranging this seminar today. I would also like to mention that I'm now speaking in my capacity as a researcher. I have other affiliations, such as being editor-in-chief and member of a board of a copyright organization and so on. So I'm purely speaking here in my capacity as a researcher. I'm a researcher at Lund University, specializing in intellectual property, and I also followed these negotiations in WIPO for the last 10 years or so. I have a question also following up on some of the comments and put forward by Thomas Mattila and Anna Vopola in relation to the functioning of intellectual property rights, and that intellectual property rights are normally rights to exclude someone from carrying out a certain activity. I have a question here. Normally, when we're talking about intellectual property rights, there are certain criteria for eligibility, such as for patents, there is a criteria for novelty and an inventive step. And for copyright, we have originality, and for trademarks, it's distinctiveness. What would the criteria be for TK and TCs from those who are experts in this from day-to-day knowledge? What would be the criteria for traditional knowledge and traditional cultural expressions to make a distinction between knowledge in general and traditional knowledge, and cultural expressions in general and traditional cultural expressions. So I would like to, if possible, some input there. And then I have a question related to beneficiaries or who shall give permission. Would it be the local Sami community, or would it be the an assembly of Sami communities, and would they have to be in consensus, or would it be a majority voting? And how about if an individual person has created something that is based on traditional knowledge, would that Sami person still have to obtain permission from the full assembly or just the local community? Some comments on this, please.
Thank you, Johan. I'm asking the Sami members in the panel if you have comments with regard to Johan's questions about the eligibility. So the kind of these elements that would separate the Sami TK or TCEs distinctively to be protected as an IP. So it's separate from a broader concept of TK and even culture. That's one point. And then the second point, in terms of beneficiaries, who would be the one who represents the Sami, in particular in cases where individuals would hold the TK or TCEs. So anyone from the Sami representatives who would like to reply at this stage? Tuomas Aslakiusa, you have the floor.
Thank you. As I was stating in my comments, that we are starting this work, and the work has to be point that Sami from different countries identify our specific model or thinking how we can move forward. So it is to me to answer to those questions too early, because we have to also be able to work more further on the details. What we have been committing now is to prioritize this as a panel issue and try to find solutions. So that is what kind of answer I can give in my role as a president of the Sami Parliamentary Council. But of course, the Sami communities, the parliaments and the civil societies together could have a certain kind of entity that would be deciding as on them own. But of course, that is tied to different issues that has to be maybe then built into legislation. Otherwise, it will not have strong enough mandate to do that. Of course, we have some good experiences now from the ethical guidelines that what we have been doing, but they in the end are only ethical guidelines. Of course, you can do a lot with that, but when, for example, in our context, we have at least today little resources, little people working, for example, with these issues, as we don't have funding enough. So we have to really be strategical on what we want and how we can reach the best results, and that thinking is under work now. But those are questions, and those are valid questions that we definitely would have to come specifically to a level of to be ready to answer off.
Thank you very much, Tuomas Aslak. It is one part of our responsibility as the governments to try to provide for the funding to clarify these issues. Any other comments or questions from the audience? We are still here with regard to the questions Johan raised. I think Tuomas Aslak is one of the highest authority on these issues, and saying that these issues are being partly going to be discussed and solutions will be found. Maybe that would be sufficient. Maybe we can move to session number 5, which would be the final concluding remarks, unless there are any other comments. Please, Paula, you can change the slide to the summary of the discussions and conclusions.